Good afternoon. We'd like to welcome everybody to today's webinar, 2023 Bankruptcy Outlook, Filing Trends, Legislation, Regulations, and more. I'm Blake Hogan, CEO of AIS. We're so thrilled to have such a large group joining us today. Hosting today's webinar will be Cliff White, who's our Managing Director of Bankruptcy Compliance. Cliff assists clients in effectively administrating default loans and implementing systems that meet the highest standards of excellence and legal compliance. For 17 years, he led the United States Trustee Program. He is the recipient of 2 presidential rank awards, the highest recognition accorded to senior career executives by President George W. Bush and President Barack Obama. Joining Cliff will be John McMickle. John is co-founder of North-South Government Strategies, a Washington, D.C. based consulting firm. He served as counsel to the Senate Judiciary Committee, where he advised Chairman Grassley on an array of policy matters under the committee's jurisdiction, including the last comprehensive rewrite of the nation's bankruptcy laws. AIS Corporate Counsel Devin Kipperly and Kate Smits will also be providing additional insight into bankruptcy servicing best practices and compliance. We have a large number of attendees on the webinar, so we've elected to keep everyone on mute. However, this is meant to be interactive, so you can share your questions by clicking on the Q&A feature or chat function at the bottom of your screen. We'll do our best to address as many questions as possible at the end of the discussion. This is being recorded, so a link will be distributed after the webinar, along with a copy of the slides. With that, I'll go ahead and turn it over to Cliff and John.
All right, well, thanks, Blake. This is Cliff White, and a belated Happy New Year to everybody. So why don't we dive in with the first topic on slide number 4. On January 18th, there was big bankruptcy news from the Department of Justice. DOJ announced the appointment of Tara Toomey as the new director of the U.S. Trustee Program, succeeding yours truly. She'll take office on February 27th. Tara has long been a prominent consumer advocate. She's currently the executive director of the National Consumer Bankruptcy Rights Center, and also of counsel to the National Consumer Law Center. I've had the opportunity to work with Tara over the years. She's a very capable bankruptcy lawyer and a committed advocate. She has spent her career on consumer bankruptcy policy and debtor representation. The obvious question for stakeholders might be whether Tara will move the U.S. Trustee Program from its traditional role as a neutral enforcer of all the bankruptcy laws for and against debtors and creditors alike, or whether she'll focus more resources on consumer advocacy. It will be of interest also to see if the program begins to push the envelope a little bit more on certain legal issues. If she devotes more resources to enforcing the law against creditor violations, or if she perhaps de-emphasizes certain traditional agency responsibilities. Finally, it may bear watching whether the USTP will team up with the Consumer Financial Protection Board to press an aggressive consumer policy agenda. So let's all stay tuned and see how that works its way out. Now to bankruptcy filings, past and future. On to slide number 5, please. This slide sets forth the bulleted points on bankruptcy filing trends that are illustrated on the slides that follow. And I'll be using these bullets and the charts to illustrate. So let's go straight then to the chart on slide number 6. The pandemic beginning in March of 2020 led to a 50% drop in overall bankruptcy filings. And the pandemic is marked by the vertical gray line on the chart. Now, in 2019, bankruptcy filings totaled almost 760,000. Last year, the number of new bankruptcy filings bottomed out at less than 380,000. Now, although perhaps none of us predicted that pandemic trend, I certainly didn't, the reasons for that trend in retrospect seem fairly obvious. An unprecedented amount of government cash relief, subsidies for businesses to keep workers employed, and moratoria on foreclosures made it less necessary for individual debtors and individual debtors and businesses to seek bankruptcy relief. Now, in 2022, bankruptcy filings continued to decrease until the middle of the year. Sticking with the chart on slide 6, the red dotted line. Are we on slide?
Slide 7.
Slide 7. We see the red, if we can go back to 6 for a second, the red dotted line that shows a lowering of the rate of decline in the number of bankruptcy filings before the middle of 2022. Changes in the rates, whether they go up or down, increase or decrease, usually offer a strong signal that trends are about to change. And sure enough, overall filings increased for the last 5 consecutive months of 2022 compared to those same months in the previous year. The red dotted slope line shows both the flattening of the curve and then the curve moving upward. Now let's take a look at slide number 7. The overall number of new filings in calendar year 2022 decreased by 5.8% compared to 2021. But importantly, the number actually increased by 4.6% over the last 6 months. And you can see that by the solid red line for 2022 being above the blue line for 2021 for the last part of the year. I think statisticians would call that a trend. And I wouldn't be surprised if we see that new upward trend persist and even accelerate in the coming year. Now let's look at chapter 13 on slide number 8. On the blue line, you can see that the climb in 13 filings began when the moratorium on foreclosures ended in the summer of 2021. And that rise has continued with few interruptions ever since. As shown on the red line during 2022, Chapter 13 filings in each month topped the filings in the same month of the previous year. So for all of 2022, Chapter 13 filings skyrocketed by 34.1%. Now, this large rise in 13s has changed the traditional ratio of 2 Chapter 7s for every Chapter 13 filed. So now the ratio is Chapter 7s at 60% of all filings and 13s at 40%. But if Chapter 7s pick up again, we may revert to the traditional ratios. And if that happens, overall bankruptcy filings would probably slope upward, perhaps steeply. So let's take a little bit closer look at Chapter 7s on slide 9. Chapter 7 filings dropped by more than 22% for the last 12 months, but filing rates had ups and downs along the way, as you can see. And importantly, notice how, again, the red and blue lines began to converge during the last 6 months of the year. Chapter 7 monthly filings were very close to 2021 filing levels during the last 2 quarters of the year. Next, the chart on slide number 10. It's usually difficult to generalize about the causes of Chapter 11 filings and to predict future trends. The number of 11s is small in comparison to total filings. That can make for significant percentage swings in filings if just one particular business sector or another experiences distress, faces high-yield bond debt coming due, or confronts other particularized challenges. Also, a Chapter 11 case with many affiliates that file separately can have a significant impact on the numbers for any particular month. Now, as this chart shows, Chapter 11s have been on a month-to-month roller coaster for the past year. The bottom line on Chapter 11s is that filings remain low by pre-pandemic standards, but show some signs of increases over the previous year that might well be sustained into 2023 and beyond. Now, for many years, investment bankers and other bankruptcy gurus told me that the key to Chapter 11 filing rates was interest rates. Well, with a doubling of the prime rate over the last year, perhaps we've reached that point. Next slide, number 11, please. If the previous discussion shows ups and downs in filings, let's finish the statistical roundup with something a little bit more constant. Subchapter 5 remains popular and effective. It's had its ups and downs throughout the year, but overall, that has remained fairly constant as a percentage of overall Chapter 11s. So as shown on this slide, over the course of the year, small business filings under Subchapter 5, which is within Chapter 11 of the Code, did slightly dip. But during much of 2022, Subchapter 5 filings were higher than they were in the same month of the previous year, especially during the last several months of 2022. Almost since its effective date, about 1 out of every 3 Chapter 11 cases was a Subchapter 5 case. Now, what are some of the reasons possible for why Subchapter 5 has remained popular? The rates of confirmation of Subchapter 5 plans are about double the historical small business confirmation rate average. And Subchapter 5 plans confirm about 40% faster than small businesses historically have confirmed. But unless Congress decides to further extend the $7.5 million debt limit to qualify for Subchapter 5, we'll probably see a significant decrease in Subchapter 5s beginning in 2024, because about 30% of all Small Business Reorganization Act Subchapter 5 cases fall between the original inflation-adjusted debt limit that's now $3 million and the higher temporary COVID relief debt limit of $7.5 million that's scheduled to expire in mid-2024. Well, enough data. Now for a discussion of what's ahead in the legislative arena, I turn the floor over to John McMickle.
Thank you, Cliff, for that excellent rendition of the stats and the data. We can even make that interesting, which is pretty hard. So I'm John McMickle. I'm an outside consultant to AIS, and I primarily focus on Capitol Hill and primarily focus on policy areas within the bankruptcy sphere. So I want to start out at a fairly high level before I scope down to the judiciary committees that have jurisdiction over bankruptcy in Congress. So the first slide that we have up here is sort of like what you should expect in the first half of 2023. So you guys, I'm sure all know from the news, after the midterm elections, Washington's going to have a divided Congress. Republicans have a slim and unstable majority in the House of Representatives. Democrats have a slim majority in the Senate. They have a 51-49 majority in the Senate. Of note, the legislative filibuster remains intact. So the magic number is not 51-60, which means that nobody really is going to run the Senate. In prior instances of split control of Congress, the end result has been legislative gridlock. That's what I expect this for at least this year and probably next. And that will be true of the bankruptcy area in particular. In past situations where DC has faced the kind of sort of gridlock in Congress, what happens is that power migrates from Congress to the administrative agencies who commence enforcement actions. So here, for your purposes, that's the USTP, the CFPB, and the FTC, which has been very active. Can we go to the next slide, please? So let me go to the House of Representatives. I'm sure you guys probably saw the drama around Speaker McCarthy becoming the Speaker of the House. He has a 5-vote margin. So that means he has very little room to maneuver. He has to hold all of his guys in line on every single vote. This is not dissimilar to what Speaker Pelosi faced in the last Congress. The first major test for Speaker McCarthy will be the federal debt limit. As you guys know, last week, the federal government ran out of the ability to, the legal authority to borrow additional funds to service existing government debt. It is expected that they will, that the executive branch will be able to use what they call extraordinary measures, sort of borrow from various government accounts in order to continue to make debt service payments until sometime in mid-June. Congress being the way it is, there's going to be a lot of posturing, but this will all pop around the end of May, the beginning of June. Now, as the slide indicates, debt limit increases are not popular with politicians and the general public. Conservative Republicans have been reluctant in the past and will be again to increase the debt limit. It's likely that they will only agree to increase the debt limit if paired with some significant spending reductions. Democrats in the Senate have already expressed that they will not agree to any spending reductions. So you can see how the drama will unfold. I think the bottom line here is when this comes to pop end of May, beginning of June, if Speaker McCarthy ends up passing a debt limit increase that relies on the votes of all the Democrats and a handful of Republicans, there will be an effort to unseat him as Speaker and insert a replacement. It is really too early to tell exactly how this is going to play out, but it's worth watching how McCarthy negotiates this particular conundrum that he's in. The Senate Republican leader, Mitch McConnell, has already said he's going to defer completely to the Speaker. The expectation is that the Senate is going to try and pass a relatively clean debt limit increase and dump it on the House and force the House to have to enact something that it doesn't like. So can we go to the next slide, please? Okay, so this is where we scope down to the House Judiciary Committee. So this is the committee that has jurisdiction over bankruptcy policy. There's a new chairman coming in with a new Republican majority, Jim Jordan from Ohio. He's indicated that oversight, big tech, the FBI, Hunter Biden laptop, you name it, will be the primary focus of the committee. As a result, I think real changes to bankruptcy law are very unlikely. The committee is likely to pass an immigration bill in the first half of the year, and like what Republicans think of as a crisis at the southern border. Jordan's office has told me that he will take a hands-off approach to managing the committee's legislative jurisdiction. If a Republican member has a priority issue, Jordan will schedule a vote if Republicans are generally supportive. This just recently happened, but Congressman Ben Cline from Virginia, who was the original author of the Subchapter 5 legislation and supports the higher debt limit that Cliff mentioned, has joined the Judiciary Committee for this purpose. There's a bullet point up here, which is true. There's a lack of support for extending the debt limit increase and some of the other Chapter 13 changes, which are due to expire in 2024. Congressman Cline is going to try and work to change that. I expect, based on conversations with staff, that it's going to be an uphill battle. All of these changes are looked at as temporary responses to the pandemic, and Republicans are anxious to move past the pandemic and communicate that in any way that they can. Can we go to the next slide after that, please? So the Senate and the Senate Judiciary Committee. Democrats now have a 1-seat margin. As I mentioned earlier, under the Senate rules, 60 votes will be required to pass most legislation. Senator Durbin will again chair the Senate Judiciary Committee. This time, Senator Lindsey Graham from South Carolina will serve as the top Republican. He has a slightly different focus. He's never really been deep in the weeds on bankruptcy policy other than student loans. The Senate Judiciary Committee will also likely focus on immigration and passing judicial nominations. Now, a Senate version of immigration reform will look very different from a House version of immigration reform, and the chances of immigration actually becoming law are still low. But some of the background noise has changed, and we'll see some action on it. It's unclear at this time whether the previously introduced bipartisan legislation related to student loans and bankruptcy will be reintroduced. That legislation never moved in the last Congress, but I will tell you it never moved because there were other items in that bill that had nothing to do with bankruptcy that created angst among certain stakeholders. It's difficult for me to see a path forward for legislation that's controversial in any way. Senate rules permit unlimited amendments, and bankruptcy bills typically attract length. It's very hard to move a discrete piece of bankruptcy policy. Everybody's got some ideas in their mind about what they'd like to move, and once you start adding, one piece to another, one piece of legislation to another piece of legislation, pretty soon you're going to have a log rolling situation, and that makes it even more difficult to pass. It's unclear whether the Senate will extend the Subchapter 5, Chapter 13 changes, although there's more support in the Senate compared to the House. I could see the Senate passing something on Subchapter 5. I just don't see at this juncture the House of Representatives taking it up. Can you go to the next slide, please? And with this, I'll turn it back over to Cliff to talk about the regulatory environment. As I mentioned, that's really where the game is going to be in terms of bankruptcy policy for the rest of the year.
Okay, thanks very much, Sean. What I'll try to do here is just recap a few regulatory highlights that we have previously discussed in blogs and alerts that are on our AIS website. Overall, the regulatory environment has turned more severe for many financial institutions and other creditors, as I think everyone on this call probably is well aware, with a number of high-profile settlements and actions. And one would expect more enforcement actions as filings rise and any errors or violations come to light. So 3 examples illustrate some of the kinds of enforcement changes that may impact the creditor community. Let me start with the DOJ guidance that was issued on November 17th of last year on student loans. It was designed to provide greater access to bankruptcy relief for student loan borrowers. Now, I flag this new guidance because if holders of student loans can more easily receive a bankruptcy discharge, then it is likely that a greater proportion of the 45 million student loan debtors will file. That means that non-student loan lenders will be impacted because those holding student loan debts will also discharge their non-student loan debt as well. A little bit of background on student loans in bankruptcy. Under bankruptcy law, student loans, whether government funded, guaranteed, or private, are not discharged unless the debtor can show that repayment would impose an undue hardship on the debtor. Undue hardship is a standard codified in the bankruptcy code. Only a small number of debtors have qualified under this standard. It's not so much the undue hardship itself as an onerous standard, but that the government itself and private lenders have successfully urged courts over the years to impose strict criteria for determining undue hardship. So, for example, in many judicial districts, courts have ruled that the debtor must show utter hopelessness of ever being able to repay. And in the last administration, Education Secretary DeVos began the process of easing the criteria to evaluate undue hardship, but she was unable to finish the process during her tenure. Now, about the new guidance. Three caveats at the outset. It applies only to federal loans, but may be expected to influence the adjudication of other student loans as well. Next, the guidance is imposed on U.S. attorneys. They're the ones who go to bankruptcy court to represent the Department of Education in collecting student loan debt. The guidance does not change the law, only how the government is going to apply the law. And the court still has to grant the discharge. And a final caveat, DOJ's determination under the guidance can only be made after a case is filed. Therefore, a student loan borrower has to take the risk and bear the expense of filing bankruptcy and seeking a declaration of dischargeability before knowing if the liability on the student loans will be eliminated. So some qualified debtors probably will not go to that time and expense. So how will the process work? Debtors who owe student loans will be asked to fill out an extensive financial questionnaire to determine ability to repay. The guidance sets clearer and more debtor-friendly standards for the government to evaluate undue hardship. And if the government agrees that repayment would impose an undue hardship, then the government may explain its conclusion to the judge, and that probably will be quite persuasive. What's the likely impact of the new guidance? Well, you can bet, first of all, that the government will oppose many fewer student loan discharges, and that may encourage more bankruptcy filings. Second, the most draconian decisions that we've seen in the past, such as a cancer victim being told they have to show hopelessness of their medical condition, shouldn't be repeated. And that's probably a good thing. And finally, debtors' lawyers probably will be able to charge maybe an extra $1,000 or thereabouts to help debtors fill out all that extra paperwork that's involved. That may not be such a good thing, depending upon your perspective. Second regulatory matter to illustrate some of the changes. DOJ's corporate criminal enforcement policies, which modified existing guidance and took a tougher line on prosecuting and imposing penalties on corporate misconduct. The Assistant Attorney General for the Criminal Division made a speech at Georgetown University just last week in which he highlighted the new policy. Let me quickly identify just three key elements that may not only affect criminal sanctions, but also may influence civil actions and penalties as well. First, monitorships are no longer disfavored. When companies, including financial institutions, have violated a law or rule, they often are required to revise internal procedures to prevent future violations. Because the government is often not in the best position to supervise the implementation of internal company policies, a third party has sometimes been put into place to oversee the remediation. The previous administration disfavored those monitors because, in their view, in some cases, not related to bankruptcy, monitors asserted undue control, ran up expenses, and went beyond their mandate. Second, corporations should self-report violations. major principle in the new guidance. If a company had knowledge and did not come forward, it will be treated by DOJ more harshly than it would have if the defendant had notified DOJ before DOJ otherwise found out. Self-reporting was a key message delivered in the Georgetown speech last week. And finally, recidivism will be treated more harshly. If past misconduct is repeated, then the government will seek more stringent remediation and penalties. And perhaps an excellent example of the philosophy of the DOJ guidance in this area was shown in a recent case brought by the CFPB, which is not itself bound by the DOJ policies. CFPB Director Chopra cited recidivism as a reason he and other regulators obtained a multi-billion-dollar settlement involving wrongful repossessions and other alleged violations. On to our last bulleted point here. The CFPB has been a very active enforcer of various consumer protection laws and reached some high dollar settlements, and we just talked about that. But as you may also have read, the CFPB itself has been under fire. Of great interest today is litigation involving challenges to the CFPB's funding mechanism. According to these challenges, defects in the funding mechanism fatally taint enforcement actions. These cases bear watching carefully in the future. In October, the U.S. Court of Appeals for the Fifth Circuit struck down the CFPB's payday lending rule and a related enforcement action on grounds that the CFPB's funding mechanism is unconstitutional. The Justice Department has asked for Supreme Court review. If that request is granted, the Supreme Court could decide that case within the next 5 months. That would be difficult to schedule so soon, but it could be done. The issue presented is a complicated one. The Constitution requires that agencies only expend money appropriated by Congress, but the CFPB is able to set its own budget within a certain statutory cap, and the Federal Reserve makes the payment to the CFPB out of the Fed's earnings. If the Supreme Court were to rule squarely and broadly against the CFPB, then the CFPB's enforcement could be crippled. A whole host of previous and future CFPB actions could be subject to challenge. Importantly as well, a broad adverse ruling also could imperil other financial regulatory agencies that collect and spend funds charged to financial institutions. But in the meantime, the CFPB does not seem to have been dissuaded from taking actions in other cases, at least outside the Fifth Circuit, and the Fifth Circuit being Texas, Louisiana, and Mississippi. So this is another area we should stay tuned for more news as this fascinating case develops. Well, with all of this talk about aggressive oversight by regulatory agencies, let's talk just a bit about some best practices to avoid falling into regulatory noncompliance. So I turn to my outstanding attorney colleagues, Kate Smits and Devin Sipperly, who have worked with many of you in addressing legal issues that arise from time to time in bankruptcy cases. Hey.
Thank you, Cliff. I'm Kate Smits. I'll address some best practices for creditors. One of the cardinal rules in bankruptcy for creditors is avoiding stay violations. Before any creditor seeks to pursue state law remedies, including repossession, demand letters, or any other collection activity, it's important that they do a search to ensure that the borrowers have not filed a new case or that any other co-debtors associated with the loan filed their own case. In terms of proofs of claim, PII, it's important to redact. Federal Rules of Bankruptcy Procedure requires the redaction of any PII, and safeguarding the borrower's information is of paramount importance. This includes loan numbers, date of birth, social security numbers, phone numbers, and now even email addresses. It's also very important to lock the PDFs before you file them. You need to ensure that any barcodes are removed and that the metadata is also removed. It's also important to ensure that the PDF is not in a writable form so that it can be manipulated. In terms of amended proofs of claim, it's important to adhere to timelines to file deficiency claims. While it's understandable that it takes time to liquidate collateral that's in your possession, please be careful when filing your deficiency claims. The timelines on this can vary by jurisdiction and can be set forth by your stay relief orders, the local rules, or even the language of the plan. You do risk the wrath of both the courts and the trustee by filing these deficiency claims out of time, so it's important you pay attention to those. With regards to mortgage notices, I'll turn this over to my colleague, Devin Sipperly.
Thanks, Kate. I'm Devin, and I'm going to talk about some best practices specific to mortgage notices. It is important to file timely and accurate mortgage notices and responses. With the notice of final cure, the rule states that the lender shall file a response to the notice of final cure. Within 21 days of service of the notice of final cure, a response must be filed even if the lender agrees the debtor is current. Failure to file a response to the notice of final cure can result in a show cause and or waiver of fees or interest. With the notice of payment change, failure to file the notice results in waiver of the payment change amount. The notice must be filed at least 21 days prior to the new payment amount becoming due. Post-petition fee notice. Make sure you itemize only allowable fees or risk fines and penalties. Notably, the post-petition fee notice must be filed within 180 days after the fees were incurred, not the date of the invoice. And with that, I'll turn it back to Cliff.
All right, well, thanks, Kate and Devin. Let me wrap up by mentioning just a couple more things. A couple of ways we're strengthening our compliance efforts that will help us identify best practices and achieve similar objectives. First, I'll mention the next to last bullet on the slide. Many of us have been working on development of a compliance dashboard where we can array relevant data and present it in a simple form to show our success in avoiding errors and violations that might run afoul of the bankruptcy code and rules. The idea is to collect data on outcomes. In other words, to see the bottom line results of our multifaceted internal policies and procedures. And there'll be more news on this forthcoming. Last point, we in AIS are also working to expand our remediation services. We do have a track record of assisting financial institutions who are cited by regulators for bankruptcy account processing or related errors. And we can help identify the affected customer populations, rectify the issues, and even help institute systems to prevent problems from recurring. Well, with all of that said, back to you, Blake.
Cliff, thank you, and John and Devin and Kate. It's been really interesting presentation. Lots always going on in this area. And if Brian, you'd like to facilitate any questions and answers, we can do that, and we'll just wrap up.
Let me pull it up. Does AIS have any thoughts as far as predictions for filing volumes in 2023?
Well, this is Cliff. I can tell you, I'll go out on a limb, at least for Cliff White, not for AIS. If I'm correct, then it's all of AIS. But if I'm wrong, it's Cliff White. I just wouldn't be surprised, for all the reasons we saw in the charts a few minutes ago, to see a double-digit increase, because we finished the last 2 quarters with almost a 5% increase in filings. And with what most commentators say is a weakening economy, I think that 5% may go up significantly. So prediction, up 10% for next year. And let's delve down a little bit, chapter by chapter. I would really watch the chapter 7s. They were down a lot last year, as we discussed, with zigs and zags. But for the last few months, chapter 7s were not down very much at all. And with the stimulus money running out, possibly a recession on the horizon, to go along with the doubling of interest rates over the last 12 months, I think 7s will rise measurably. And 7s represent the majority of all filings. So prediction for 7s is at least a 5% increase. 13s, where we had that more than 1/3 increase last year, hard to keep that pace, but even in the fourth quarter, it was up, 13 filings were up by 27%. And with refinancing maybe more difficult now, to refinance a house, which is a way a lot of borrowers avoid having to file bankruptcy, or maybe with variable interest rates exceeding family budgets, the 13s will keep that pace of the fourth quarter, which means up by another 27%. Now, I'll go way out on a limb on 11s, which are interesting because they're subject to the wild swings we saw before. with related case filings or industry-specific problems. But, you know, if those analysts who were telling me for the last 10 years that Chapter 11s will go up when interest rates go up, interest rates doubled. So I'd say a very big increase, even above 25% is quite possible. So that's it, up by double digits. That's not an official AIS policy perhaps, but I'll stand by it.
Okay, thanks, Cliff. Your presentation indicates Chapter 10 is on hold. Is there any momentum for such a significant change in the bankruptcy code?
Chapter 10, well, I don't know if you mean Chapter 10. That was a proposal from a few years ago to create a specialized bankruptcy process for bank holding companies. I think you might mean subchapter 5.
Maybe Senator Warren's bill.
Oh, Chapter 10, the unified, oh yeah, that is not going to pass. The Republicans hate it. She does not have enough support even among Democrats. I doubt that she has 51 votes in the Senate. But so this idea of a unified consumer chapter is not going to pass. I haven't seen it reintroduced. There was going to be a hearing on that legislation at the end of the last Congress, the fall of last year. But the Democrats in the House who were going to have the hearing decided to cancel it because it was too politically dicey for them to continue down that road. Sorry for the confusion.
Okay, for the new compliance dashboard, can you share some of the metrics and activities AIS will be tracking?
Yes, this is Cliff again. I mean, we're looking at the stages of a bankruptcy case and looking at areas where there's the highest risk of violations. And Kate and Devin just covered some of them, but more specifically, the first stage of the case, of any case, is the automatic stay. It's imposed the millisecond the case is filed. There's the risk of such things as wrongful repossessions, improper collection activities. So we want to make sure that we're measuring the automatic stay and adherence to it. Next stage, or days later, weeks later, proof of claim is filed. And as Kate said, then it's all about accuracy, and more accuracy in every bit of information filed with the court. And that is an area where a lot of actions against creditors have been taken in past years. The discharge injunction, when the debtor, it doesn't mean the case is necessarily over. The case can go on and assets marshaled after a discharge injunction. But there again, there's the risk of things such as wrongful repossession, depending upon balances due, as well as the risk of improper collection activities. So measuring that. The mortgage actions, and that's very important, as Devin explained, the required notices in the bankruptcy rules. Personally identifiable information. Lenders have to follow the federal rules of bankruptcy procedure provisions to redact. And so not only is it important to redact what you are required to redact, but also to remember, because we see this sometimes as the cause of a lapse, the failure to train staff on the technology that will allow the redaction to occur. And there are other risky areas too that we'll be covering, such as reaffirmations is a risky area where creditors sometimes go wrong. Also, failure to obey court orders that don't fit neatly within certain tracking systems, but they've got to be tracked. So we want to make sure those kinds of things are captured. There might be anomalies. But what's the goal? Evaluate actions at the major stages of a bankruptcy case, track the outcomes, and then present the results in a visually helpful way to AIS and to our clients.
Okay, thanks, Cliff. I think, Blake, I think we can wrap up. Again, just as a reminder, everybody who participated today will receive a copy of the slides as well as the recording to the actual live webinar.
Great. Thanks, Brian. Thanks, Cliff, John, Kate, Devin. With that, we'll wrap up today's meeting. Hope everybody has a great day. Look forward to talking to everybody soon.